Morning, Your Honors.
How are you, Mr. Caldavia?
Very well, thank you. I am having trouble hearing Judge Jacobus, though, just for the.
I was wondering, maybe Judge Jacobus, you might be sitting a little far back from your mic. I can't tell for sure, but
Could be.
We've
Yeah.
got an echo in.
Better?
He's
Is that better? I don't even know where the mic is.
lately.
I guess it's.
I'll listen carefully.
he's soft-spoken, carries big stick. You know.
All right.
Clues. Can you hear me better this way?
Yeah, maybe when you speak up a little bit and sit closer to the mic.
I'll talk a little louder.
Just if you're conscious of it, it should be okay.
Okay, thank you.
Okay, Mr. Caldavia. I'm sorry, Mr. Altenburn, you're up.
I'm up, yes. May it please the court, my name is Chris Altenburn. I'm a member of Banker Lopez Gassler, and I'm here today representing Nationwide Insurance Company. I'd like to save 6 minutes for rebuttal. The issue on this appeal is whether after the legislature amended the PIP statute in 2012, Medicare payment methodologies may be used by insurers to determine the appropriate amount for pay for medical services. All of the cases addressing this issue have done so in the context of a medical bill where the PIP statute adopts by reference the participating physician's fee schedule of Medicare Part B as the schedule to use in calculating the allowable amount payable for that bill. A year ago, this court heard another case for Dr. Crespo, the McCulley case, and it presented the same issue. Judge Northcutt was on that panel and the case was per curiam affirmed. I've watched the oral argument and it appears likely that the attorney for the insurance company may not have convinced the court that the trial judge was necessarily wrong, but the panel was not so confident about the correctness of the trial court's order to write a binding precedent adopting the trial court's reasoning for use in future class actions. About 2 weeks later, the Fourth District issued its decision in Stand Up MRI, which squarely holds that the Medicare payment methodologies could be used in this context. The opinion in that case explains that the amount determined by the fee schedule is not a floor, and that the provisions in subparagraphs 5A1 through 3 of the PIP statute all work together to determine the method to calculate an appropriate reimbursement for medical services when the calculation is based on the participating physician's fee schedule. Returning then back to this court's decision in McCulley, both the insurance company and Dr. Crespo encouraged this court on rehearing to write an opinion. But after the Fourth District denied rehearing in Stand Up MRI, this court also denied rehearing in McCulley and allowed the Fourth District's case law to become the controlling case law in Florida. Thus, at this point, the trial court's order on appeal is in direct conflict with the controlling case law from the Fourth District, which binds Florida. Accordingly, this court has either the choice to reverse the trial court or to write an opinion that expressly conflicts with the Fourth District so that the conflict could be resolved by the Florida Supreme Court.
Well, there's no conflict now, correct, as you point out, but you have a problem with it in terms of trying to tee this up based on the med pay issue in this case.
I was hoping to save that for the rebuttal part of my case.
Well, of course,
but
it's going to come up, we know.
It's going to come up, and the bottom line is, as I've explained in the briefs, that the standard Medicare issue was pled all along, which was that when you have Medicare in an insurance policy, the insurance company pays the first 80% of the allowable amount under the PIP policy, and it picks up as the co-insurance portion of the insured under the 20%. So the $32 and change amount in this case is not the 80% amount for PIP, it's the 100% amount that is the combination of PIP and MedPay, and that's never really been in dispute. But when after Mr. Caldavia appeared in the case and I appeared in this case, if McCulley was not affirmed by this court, he needed to have a backup plan to make an argument about the $32. And his plan was to argue that the Medicare, that the MedPay policy could pick up and cover that language. And even though that separate claim hadn't been alleged, to speed this up, I agreed we could go ahead and brief that issue. And we did brief that issue. In the process of briefing that issue, Mr. Caldavia basically morphed the issue into one that was not a $32 issue, but would have been a much larger issue, not only in this case, but in lots of other cases. And that's when I objected to the court doing anything. Now, what happened was the court actually did PCA the case in McCauley. And literally, maybe it was the same day, within 24 hours, the trial court quickly entered the short order continuing to apply the McCauley and Scoy decisions in this case. So she was probably happy not to have to read all of the briefing we put in on MedPay, and she made no decision on that. Now, Mr. Caldavia claims that I did not appeal and have waived something concerning MedPay, but there was no rendered order. And so there was nothing I could bring as an appeal on MedPay because there was no decision by the trial court on that. What he's arguing to you is that somehow under Tipsy-Coachman, this case, which was and has been basically a fight over the language in the PIP statute, can now shift to being a fight over the nationwide policy on MedPay. That would be the most extreme application of the Tipsy-Coachman doctrine that I think I've ever seen. I don't know that there's an example that extreme anywhere in the case law. You have a fair amount of discretion as whether you do or don't apply the Tipsy-Coachman doctrine. But
I mean, a lot of policies are written, I mean, we're talking just beyond nationwide, obviously. But a lot of policies are written just with PIP coverage and no MedPay, correct? In other words, MedPay is not always part of someone's.
That's correct. The MedPay, except for a very brief point in history, has never been regulated by the insurance code other than you have to submit the policy for approval to OIR. So you can have any kind of provisions about MedPay.
Right.
Now, since co-insurance kicked in PIP in 1976, many of the MedPay policies do what this policy does, which is recite precisely the language of the PIP statute and say, this is what we're going to pay.
Right.
And we're going to pay the co-insurance part as well. And the language is designed so that when PIP exhausts, they continue to pay like PIP under the MedPay statute. So even if you get to the merits of that issue, if you look at the briefing that we did in front of the trial judge that she never ruled on, I think our policy is clear that it is a policy that does not cover beyond the portion of the $32 that we have agreed to have in this judgment all along.
I got it.
But, you know, the Tipsy-Coachman can be a dangerous doctrine. And frankly, he brought it up in an answer brief.
Well, you know, here's the thing. I mean, they alleged PIP and MedPay from day one in their complaint.
Yes, the 20%, but we never contested.
So how is the judgment going to be different?
Well, you'd have to go back if you enter an opinion, which you should, reversing the trial court because it did not apply what is now the law of Florida under stand-up MRI. That I have never contested that they could go back and try to argue about MedPay. They can do it on remand here, or they can do it in another lawsuit, or even with another party. But the notion that this court should decide an issue that could involve literally millions of dollars in a class action and all of that, based on what he argued in an answer brief and what little I could put into a reply brief, frankly.
Based on what's in their initial complaint.
No, their initial complaint was a standard tag-along complaint for MedPay. They have never alleged that if this wasn't covered by PIP, that somehow all of it would be, despite that, covered by MedPay. That arose at the very end when he thought he was going to lose McCullough. And if you look at the stipulations at the beginning of the transcript, that is what we did in this case. At this point, I'm beginning to regret my professional courtesy in allowing this to be done in this fashion. But this was not something that a standard PIP complaint, and this is a plain vanilla standard PIP complaint, always alleges that it's both PIP and MedPay in case that they can pick up the other 20% by MedPay. And we never, ever at any contest about whether or not we were going to pay that 20%, which is in this $32 and change judgment. So as a result of that, the notion that this case should be one where you could extend the Tipsy-Coachman doctrine to decide this is frankly a violation of due process, I think. But
Well, that's a pretty strong statement, Judge, Mr. Altenburn.
yes, it is.
But here we have a case in which the failure to pay is alleged to have been a failure to pay either, the PIP or the med pay. And I know you're trying to, you're trying to get an opinion on, out of us on this law, but you're asking us to do it in a case that is complicated by this med pay issue. It's not a clean case.
Well, the med pay issue was never ever ruled upon.
At least on the meetings, has been alleged from the start. And the Tipsy-Coachman rule applies whether the judge ruled on it or not. Doesn't it?
Normally, the Tipsy-Coachman applies when you have an issue that is a singular issue that can be resolved in one of two fashions. Here, we had a cause of action under PIP with the tag along 20% that was uncontested under MedPay. You had, if there's a failure of PIP, then there's a whole new theory under MedPay.
You call it a tag along, but you're characterizing it that way doesn't alter the fact that that MedPay provision was one of the bases for the breach of contract suit from day one.
I truly doubt that when they filed this thing, that's what they said. But if you want to go in that direction, then we go to the language of the policy.
I'm looking at complaint.
Yes.
The failure of the defendant to pay PIP and or medical payment benefits in accordance with the law. Plaintiff has been required to repay the undersigned law firm. Defendant failed to make proper payment of PIP and or medical payment benefits and interest payments. I mean, this is alleged all over the initial complaint.
Yes, and it will be in 1,000 other PIP cases because they want the other 20%.
Of course they do. That's what the MedPay is for, and that's why I question whether you're in a different.
You don't understand. It's not the 20%. They want to be able, if you read their memos, they want to be able to charge $180 or more on this. On a case where we stipulated the damages were $32.
Mr. Altenburn, I do understand that the result that if we were to write the opinion you want us to and send it back, you're going to get the same judgment, are you not?
Well, I'll get a judgment from a trial court that has had a case argued in front of it, and if need be, evidence presented on the MedPay policy. That policy says it's over and above PIP. And then it lays out that it's going to pay per the rate of the schedule of maximum charges set forth in Florida's motor vehicle law as amended using the Medicare coding policies and payment methodologies of the federal centers of Medicare and Medicaid services. It tracks the language of the PIP statute. So if there is a decision that the PIP statute does not pay this, then this is voluntary coverage, is freedom of contract. If the PIP statute doesn't cover it, neither does this contract. The so-called flush left sentence is the sentence that explains that we're going to pick up the amount that's otherwise due for the co-insurance provision.
But you don't disagree. You never contended that the PIP coverage doesn't apply in this case.
The PIP coverage does not cover the $32. That's what this is all about.
Right.
And the fourth district's opinion says that the PIP coverage does not cover the $32 because of the fact that subsection 3 has the however sentence in it that specifically now does adopt by reference the payment methodologies into the process of deciding what the appropriate amount is to pay under the no-fault statute. So, yeah, the dispute here is purely a matter of at the front end of this is purely a matter of what the statute says, because the statute is incorporated verbatim into Nationwide's insurance policy, and as a practical matter, the PIP statute now requires in section 7 and 766.27.7311 that those things be deemed to be in the policy one way or the other.
I've helped you get to your rebuttal time, so you can use your 6 minutes as you wish.
Well, I will save my 6 minutes. Well, I don't know. I've not gotten to argue what I wanted to argue about stand-up MRI, but the bottom line is that before there was a floor, or there was confusion about whether there was a floor created by subsection 1. And as the 4th District explains in stand-up MRI, after the statute was amended, it is very clear that this process you go through to determine the singular schedule of maximum charge is you go through and you look at the provisions of the participating physician schedule part B. You determine under subpart 2 which year applies. In this particular case, there's no drop down to 2007. It's just, I believe, year 2017. And then you go to subsection 3 and determine that there's no payment methodology that is a utilization limit, because everyone agrees with that. You check, and the second sentence simply says that if this is being provided by someone such as a chiropractor who might not be reimbursed under Medicaid law, Medicare law, they still get it reimbursed under Florida law. And so that would happen here as well, as the 4th District has explained. But even if it were a chiropractor that had problems, the 4th District has explained that the third sentence, the however sentence, says that however, no matter what's in subsection 1, the payment methodologies and the coding procedures apply. Judge Jacobus, when he was on the 5th District, wrote a case called SOC that was under the 2008 statute. The other side says that case law still applies, but it was under the older case law, and the explanation in that was that the legislature had failed to incorporate by reference any of the payment methodology language into the statute. And it was immediately after those cases, with all of the cases that were pending in county court, that they amended the statute with a however sentence to say, however, yes, you can use payment methodologies and coding policies. So I suppose if Judge Jacobus still thinks his case is binding, he can tell you that during conference. And I'll save the rest of my time for rebuttal.
Okay, you have about 4 minutes left, Mr. Altenberg.
Thank you.
I got to tell you that Judge Torpey applies the blind squirrel doctrine to my cases.
Okay, Mr. Caldevilla.
May it please the court. Good morning, your honors. I'm Dave Caldevilla, and I represent Dr. Crespo's office in this appeal. The trial court summary judgment is correct and it should be affirmed. Let's get a couple of things straight right off the bat, though. This is not a class action case. This is a small claims case over $32.31. And MedPay, it's a breach of contract on 2 bases. The insurance company violated the PIP coverage provision. It violated the MedPay provision, or both. It's $32.31 because there's MedPay. If there wasn't MedPay, if the insured patient had not purchased MedPay coverage, this would be a case over $25.85. Okay, so let's be clear about that. The judge did issue an order granting MedPay because you can't get to $32.31 without there being MedPay. I was going to start with the PIP portion, but I think I should go to MedPay first. So I'm going to rearrange myself. But Judge Northcutt, I think you're hitting the nail on the head. First of all, I think that the trial judge was absolutely correct on the PIP analysis that she did in the McCulley case, which this court affirmed. She followed that right after this court affirmed. That was a correct analysis, and I'll get to that. But let's say Mr. Altenburn is correct and she's totally wrong about that, and they paid the correct amount of PIP coverage. Well, when you buy MedPay, it's because you don't want to pay any portion of the medical bill. You want the insurance company to pick up the rest. And if you read Nationwide's policy on MedPay, it says they're going to pick up the rest. It doesn't say we'll pick up to 20% of the medical bill. It doesn't say that anywhere. It doesn't say we'll pick up the difference between what the fee schedule paid under PIP and what the fee schedule, what's left under the fee schedule. Doesn't say that. It says, look, when we paid MedPay, we're going to look at that amount and we're going to apply the fee schedule. Well, that's 170 something bucks on this case. We're talking about $32 that both sides stipulated would be the amount in controversy. That 32 bucks is subsumed by the 170 something dollars that would come up under the fee schedule, even with their 15% discount they're not entitled to. Okay. And then on top of that, on top of their acknowledgement that they'll pay the percent of the fee schedule, then there's the left language of their policy that says they'll also pay anything else. And that's right out of the old PIP statute, subsection 4F of the PIP statute had the same exact provision, and the courts had interpreted that provision of the PIP statute to mean that MedPay is to cover 100% of the medical bill, whatever PIP doesn't cover. Apparently, Nationwide chose never to amend its policy to cap that off. They're trying to provide good coverage. Of course, that's what they advertise anyway, that they want to be on your side, but when it comes time to collect on the bill, not so much. So if Mr. Altenburn is absolutely correct on PIP, which he's not, this is a harmless error case because if you remand it, it's going to be a judgment for $32.31. Everything, that whole bill is covered by MedPay. Now we stipulated $32. I could have asked for more, but we didn't. We agreed $32.31. Now, there's also seems to be confusion about what was pled and what wasn't pled. We pled MedPay, Judge Jacobus.
Yes. Do you agree that they were entitled to the discount on the PIP coverage part of it? In other words,
No, sir. No, sir. And I'll explain why.
You don't, okay. In other words, you don't think
I'll get to that.
right or whatever. You don't think
Right. That's a failure to follow the whole text canon of statutory construction, and I'll explain that right now. But I just want to make it clear that if this case goes back down, it's a $32.31 judgment anyway, which is what the judge ruled, and you can't get there without MedPay. So the judge did rule on it. There's confusion about what was pled and not pled. Judge Jacobus, I'll get right to your point right after this. What was pled was MedPay 8 times. This is a breach of contract over 2 types of coverage. What was never pled is an affirmative defense that they claimed to apply the nurse practitioner methodology of Medicare. They raised one affirmative defense that they paid pursuant to 5A1F. Well, they didn't. They chopped 15% off of that. So if there was something not pled, it was the argument that Mr. Altenburn is trying to present, which is beyond the scope of the pleadings. All right. So if we want to talk about something not being pled, let's look there first. But he's wrong on the statutory interpretation. So I need to walk you through the PIP statute. Unfortunately, it's long and complicated. And if you have my answer brief, Andy, it begins on page 26.
Yeah, why don't you take us through the IRS code while you're at it?
That might be a little simpler, to be honest. And this PIP statute has been amended 60 times since 1971. So on average, that's more than 1 time per year. And trust me, the doctors are not the ones who are lobbying for these changes in the PIP statute. It's the insurance industry. And then they're never happy with the language that they successfully convince the legislature to adopt. But starting on page 26, the fee schedule method, page 26 of my answer brief, going through the PIP statute. The fee schedule method starts at subsection 5A1 of the PIP statute, and it says the insurer may limit reimbursement to 80% of the following scheduled maximum charges. After that, there's 6 subparagraphs, A through F. Let's look at A, the very first one. For emergency transport and treatment by providers licensed under Chapter 401, they get 200% of Medicare. All right. Now, that's the standard that Mr. Altenburn wants to apply to nurse practitioners. 200% of whatever Medicare pays, that's what you get if you're an ambulance driver. That's what Nationwide wants to pay to nurse practitioners. But It doesn't say nurse practitioners there. Let's go to B. Now, every one of these subsection is completely different. All right, it's very specific as to the type of services and providers. For B, if you have emergency services in a hospital, the hospital gets paid based on 75% of its usual and customary charges. Now, let's stop there for a second. If Mr. Altenburn is right, that the third sentence of 583 applies to all these fee schedules, then he must have to contend that Medicare payment methodologies applies to 5A1B for emergency services rendered in a hospital. But the legislature says, no, it's 75% of the hospital's usual and customary charges. How can Medicare even apply to that? Obviously, the third sentence of 5A3 does not apply to every subsection. Let's go to C of the fee schedules. For emergency services provided in a facility, that's a hospital, rendered by a dentist or physician, then it's going to be the usual and customary charges in the community. Not 75% of the hospital's usual and customary, but 75% of the doctors or dentists' customary charges in the community. Again, how does the third sentence of 583 possibly apply to that? It doesn't. Let's go to D. For hospital inpatient services that are non-emergency, they're going to get 200% of Medicare Part A prospective payment applicable to that particular hospital. All right. So that there's no fee schedule mentioned there. It's just Medicare Part A prospective payment that applies to that particular hospital. E, for hospital outpatient services that are not emergency, they get 200% of Medicare Part A ambulatory payment classification for that specific hospital. Okay, no fee schedules mentioned there. F, this is the one that applies. For all other medical services and care, they get 200% of the allowable amount. And then in 2012, they broke subsection F into 3 Roman numerals. And it's very interesting. So let's look at the Roman numeral 1 is where we are. If you're all other services other than Roman numeral 1 and 2, you're going to get the participating fee schedule of Medicare Part B. So you get 80% of 200% of that fee schedule, not 80% of 170%, which Mr. Altenburn wants to apply to nurse practitioners. And so it's a very specific, the participating physician's fee schedule. But let's go to Roman numeral 2. Look what it says. If you're a ambulatory surgical center or clinical laboratory, you get 200% of Medicare Part B. Doesn't say the Medicare Part B participating fee schedule. So it's broader. If you're a ambulatory surgical center or clinical laboratory, you're going to get whatever Medicare would pay under Part B, under all their regulations, all their payment methodologies. That's what you get. But Mr. Altenburn would have you put nurse practitioners into that Roman numeral 2, because that's what he wants to do. He wants to say, you're a nurse practitioner and you provided non-hospital, non-emergency services. Well, you're going to get 200% of whatever Medicare would pay under Part B. They're just ignoring all the rules of statutory construction. Now, the 4th DCA cases, they decided an MPPR about a MPPR payment methodology, and it's not binding in this case. This case is nurse practitioner, so it's distinguishable just on the facts. MPPR is a bundling issue, okay? So it involves providing multiple services by the same doctor at the same facility on the same day. If you go to subsection 5B for boy in the PIP statute, it says that healthcare providers are not allowed to unbundle the services that they render. So if I'm a doctor and I render 5 different CPT codes worth of services to an insured patient that day, I have to bundle them together because I get economies of scale by doing things in my office all at the same time. I'm not allowed to unbundle them. I have to treat it as though it was one glob of services that day and I get paid less. That's what MPPR is a type of bundling issue. So is NCCI edits. It's a bundling issue. This is a question of the type of services rendered by a particular type of discipline or healthcare provider and the particular type of restrictions and limitations that Medicare provides. That is specifically addressed in the second sentence of 5A3. The second sentence of 5A3, and by the way, everybody agrees in this case that there's no utilization limits applicable in this case. So all the 4th DCA cases that say, oh, MPPR is not a utilization limit, I don't care, it doesn't have anything to do with this case. And there are quite a few decisions that are focused just on that issue. Irrelevant here. But the second sentence of 5A3 says an insurer that applies the allowable payment methodologies in subparagraph 1, which is 5A1, must reimburse a provider who lawfully provided care or treatment under the scope of his or her license, regardless of the limitations on the type of disciplines of the healthcare providers who may be reimbursed. Okay, so we're talking about it. This is exactly what we're talking about. It applies to chiropractors. The 4th DCA said, hey, insurance companies, you can't apply this Medicare 2% discount on chiropractors under the PIP statute because 5A1F says you get 200% of the participating physician's fee schedule. You don't get a 2% discount on top of that. They went right to it. And then 2 weeks later, the 4th DCA doesn't pay any attention to what the rest of the statute says. In fact, Justice Scalia says that is the most common interpretive fault when construing statutes is not to look at the whole statute and read everything in harmony. And that is exactly what all those 4th DCA decisions do. They don't look at 5A1A to see that emergency transport providers, ambulance drivers get 200% of whatever Medicare pays. They didn't look at F Roman numeral 2 to see that ambulatory surgical centers and clinical laboratories get 200% of whatever Medicare Part B would provide. Didn't compare those. And what they're just basically saying everybody gets paid based on what Medicare pays. Whatever Medicare pays, we'll double it and you get that. Well, no, there's 8 different categories of medical providers, and every single one of those categories has a very specific payment limitation that the legislature intended. If they wanted to apply all Medicare payment methodologies across the board to all these, you wouldn't need to have all those various subsections A through F, Roman numeral 1 through 3. They just say you get paid 200% of Medicare, just like 5A1. Or they may say if you're non-hospital, non-emergency, then you're going to get 200% of whatever Medicare Part B would pay, which is what Nationwide wants to pay my client. It's wrong. The specific controls the general. All the specific provisions of A through F control the general provision of the last sentence of 5A3. This is just textbook statutory construction. There's no hocus pocus here. This is just a complicated mess of a statute, but it's pretty clear what they want. And let me also say, Judge Jacobus's decision, the SOCC versus State Farm, I'm pretty sure was issued after the legislature amended the 2012 statute. So the legislature did not intend to overturn Judge Jacobus's decision. The legislature in 2012, when they amended the PIP statute, there are reports after reports after reports and staff analysis about everything that they wanted to do. This was a very comprehensive piece of legislation. Not once does it say that they wanted to overrule this court's decision in AFO versus Nationwide. Not once did they explain what that third sentence of 5A3 was supposed to address. And let me say, at that time, there was also a debate over whether the limiting charge versus the non-facility charge was the participating physician's fee schedule allowable amount. The third DCA said it's not the limiting charge. Limiting charge is higher than the non-facility charge. Well, if you dig into the Medicare regs, you find that the allowable amount, when that term is used by Medicare, it means the full amount of the participating fee schedule, which corresponds to the non-facility charge. You don't get the limiting charge bump up. You don't get less either. You get the participating physicians the full fee schedule amount. And that was decided, in fact, there's case law, published decision by Judge Barton, AFO versus Peak, which included Nationwide, by the way. He held that anyway, that decision was, he interpreted the second sentence, and that case was appealed to this court, Nationwide versus AFO, and this court agreed. Let's just look at what 5A1F says. It says the participating physician's fee schedule. That's what you get. Yes, payment provisions and coding policies, payment methodologies and coding methodologies can be applied. Certainly coding policies apply. They apply to everywhere. And that's already in 5E of the PIP statute. You have all doctors, when they do a PIP claim or a MedPay claim, they have to use the official CPT code methodology adopted by Medicare. So yes, the coding policies apply. You can't bundle things, you can't unbundle things that are supposed to be bundled. Payment methodologies, they even apply to what I'm talking about. They apply because you need to know a Medicare payment methodology to read the fee schedule. When you plug the CPT code into the fee schedule website, you get 4 numbers. You get a non-facility charge, you get a non-facility limiting charge, you get a limiting charge, you get these 4 different numbers. You have to know Medicare payment methodologies to know that we go to the non-facility price for a 5A1F non-emergency, non-hospital situation. So yes, we give meaning, my analysis gives meaning to every one of these provisions without rendering any of them meaningless. Mr. Altenburn's argument renders meaningless everything from 5AB through 5AF, Roman numeral 1. He gives meaning, he wants to treat every healthcare provider, or at least nurse practitioners, the same way that an ambulance driver is treated, same way that an outpatient surgical centers treated, the same way an ambulatory laboratory, the clinical laboratory is treated. If that's what the legislature wanted to do, in 2012, when they were busy amending this statute, they would have put nurse practitioners right there under Roman numeral 2, right next to clinical laboratories and ambulatory surgical centers. But they didn't. They didn't do that. And they would have stricken the second sentence of 5A2. They would have stricken it to say that, oh yeah, you can apply restrictions if Medicare treats certain providers different, you can treat those restrictions and limitations on those, apply them on chiropractors and nurse practitioners and physician's assistants, et cetera. But no, they didn't do that. So, Your Honors, this is a case that needs to be affirmed. Judge Peroni was absolutely correct in her analysis of the PIP statute, but even if she wasn't, this policy picks up the difference. At best, this would be a harmless error case because they have not appealed the MedPay issue. It was pled everywhere. They chose not to appeal it. Why? Because they can't win it. And they said that I'm raising a cross appeal. I'm not raising a cross appeal. I'm seeking to affirm the whole thing.
You were winding up there, Mr. Caldavilla, because I think you knew your 20 minutes was up, but now you've gone another stretch. So
thank you, Your Honor. I appreciate your patience with me today.
I'm always patient with you, Mr. Caldavilla.
You are, Judge. I appreciate it.
Mr. Altenburn, you're up. You have what I think, say 4 minutes. Is that what it was?
Yes. Let me start off with saying that virtually everything that he has just argued to you about the PIP statute was argued and rejected by the 4th District. The 3 cases that I've cited to you from the 4th District have disagreed with all of those arguments. His notion, he goes always through this long litany to confuse you about all the schedules that are in the singular schedule of maximum charges. But the case law has addressed only the schedule in F1, which is the participating physician's schedule of Medicare Part B. If you look at the statute, that is the only one of those schedules in that list that says it applies to all other medical services, supplies, and care. And when the Salk decision and others said that the statute needed to adopt by reference, more specifically, the payment methodologies, the legislature amended subsection 3 to add the however statute sentence, which says that it is going to apply payment methodologies to medical services, supplies, and care. The statute expressly lined up with what was in front of here because that was in the problem, not just in AFO and SOC, but in all of the other cases that have been underlying it in the county courts. So this was very clearly an effort to make express in the statute and adopt by reference that part of Medicare. That is what the trial court did not do. The trial court's judgment is based exclusively on the reasoning in McCauley. She had entered a $32 judgment, $25 of which is payable under PIP, and the other is the undisputed amount that is the copay that's under the language in our MedPay policy. And so you would have to, if you're going to reach the MedPay policy for anything more than the amount we've never disputed, you have to reverse this judgment on its reasoning and then jump to the Tipsy Coachman argument about can we pay the $32 under MedPay? Because Nationwide, after all, has already paid all the rest of this claim, $180 or so, under PIP coverage. There was no dispute about that. So then you have to go back to the language of the MedPay, which is unregulated language. He hasn't talked about that at all here. I've not had a chance to brief that, and I've asked in my earlier brief that if you actually want to go to the Tipsy Coachman, I think I ought to have the right to at least brief that issue other than 300 words in a reply brief. But the language of if you then shift and do an analysis to say, okay, is the $32 or some unstipulated amount that's higher than $32 payable under MedPay coverage, what does the language says? And it's over and above PIP, and it says that it will pay the benefit per the rate of the schedule of maximum charges set forth in the Florida Motor Vehicle No Fault Law, using Medicare coding policies and payment methodologies. The contract adopts the very statute that the 4th District says doesn't require the payment of the $32 from us to Dr. Crespo. So you have to write a completely different opinion to reach that subject. His second paragraph in there is the paragraph about the coinsurance, which we have never disputed about our willingness to pay. You need to look at the stipulation at the beginning of the hearing, because Mr. Caldevilla and I made these things simpler at the beginning of the hearing. I would point out that there was no argument raised whatsoever that I needed to amend my affirmative defenses. We went straight through this. The first time I ever heard that was in the answer brief. That is simply not
minutes, Mr. Altenburn, so you need to wind up.
All right. So in the end, the 4th District is right on the PIP issue, and you therefore need to reverse this case. If you decide to go on to Tipsy Coachman, it will be the most expansive use of Tipsy Coachman I have ever seen. But if you do that, you still need to look at the language of our contract and decide that it's covered within that language, not what Mr. Caldevilla has explained to you is the language of the policy, because it's not.
Okay.
Thank you very much.
Thank you both. In order to leave, you need to click